All rise.
The Kosovo Specialist Chambers is now in session.
Please be seated.
Good morning and welcome everyone in and outside the courtroom. Madam Court Officer, can you please call the case?
Good morning, Your Honor. This is case KSC BC 2020-06, the Specialist Prosecutor versus Hashim Thaci, Kadri Veseli, Recep Selimi, and Jakub Krasniqi.
Thank you, Madam Court Officer. Now I would kindly ask the parties and participants to introduce themselves, starting with the Specialist Prosecutor's Office. Madam Prosecutor.
Good morning, Your Honor, and to everyone joining. For the Specialist Prosecutor's Office this morning are Alan Teager, Senior Prosecutor, David Harbach, Prosecutor, Nathan Quick, Associate Team Leader, and Marlene Yaya Hagi, Legal and Disclosure Officer. And I am Claire Lawson, Head of the Legal Office. Thank you.
Thank you, Madam Prosecutor. Now I turn to the defense. May Counsel can introduce themselves and their team, starting with Mr. Prosper, please.
Good morning. Pierre Prosper on behalf of Mr. President Thaci, and I have with me Dasted Palaska here as co-counsel. Thank you.
Thank you very much, Mr. Prosper. Mr. Emerson, please.
Good morning, Your Honor, and to everybody in the courtroom. I'm appearing today on behalf of Mr. Vasili, together with my co-counsel, Mr. Nick Kaufman.
Thank you, Mr. Emerson. Mr. Young, please.
Good morning, Your Honor. David Young for Mr. Recep Selimi today. Thank you.
Thank you, Mr. Young. And Ms. Alagendra, please.
Good morning, Your Honor. Venkateshwari Alagendra, appearing for Mr. Jakub Krasniqi, together with Mr. Aidan Ellis and Mento Bechiri.
Thank you, Ms. Alagendra. For the record, I note that Mr. Thaci, Mr. Vasili, Mr. Selimi, and Mr. Krasniqi are not present physically in the courtroom, but attend this hearing via video conference. Now I turn to the counsel for victims. Mr. Laws, please.
Good morning, Your Honor. Simon Laws, assigned counsel for the victims in this case.
Thank you, Mr. Laws. And now I turn to the registry. Mr. Roche, please.
Good morning, Your Honor. Ralph Roach, Judicial Services Division.
Thank you, Mr. Roche. And for the record, I'm Nicholas Guillou, pretrial judge for this case. Before we proceed with our agenda today, I remind the parties that should anyone attending the status conference via video conference experience any technical difficulties, please inform the court officer and myself immediately by waving your hand. Let me now move to the recent procedural history of the case. On 14 May 2021, I scheduled this fourth status conference. I asked the parties to provide written submissions, if they so wished, on the following topics: disclosure, defense objections to the admissibility of Rule 102 evidence, the status of SPO investigations, the status of defense investigations, the points of agreement on matters of law and fact, the date for the next status conference, and any other matters they wished to raise. On Tuesday, 18 May, the SPO, the defense for Mr. Vasili, and the defense for Mr. Krasniqi submitted their written observations. I thank these parties for their written submissions. The purpose of our hearing today is to review the status of the case and to discuss the topics I just listed. I will invite the parties to present their views in a concise fashion about each item. I remind the parties to give prior notice should any submission require the disclosure of confidential information so that we can go into private or closed session. Before we start with our agenda, I would first like to thank the parties for their responses and replies to the preliminary motions. And I inform the parties that I will issue an oral order at the end of the status conference regarding the time limit to issue my decisions on the preliminary motions filed by the defense. And before we go through the agenda set out for the status conference, I would also like to briefly discuss the issue of translations. I note that the defense for Mr. Krasniqi raises the issue of the translations, in particular, the translation of the Rule 86.3b outline and the translation of filings which it has requested priority. I would first like to hear from the registry on the progress it has made with regard to the translation of these items. I note that at the status conference held on 16 February 2021, the registry indicated that it could provide the first 150 pages of the Rule 86.3b outlined, revised and translated no later than 20th April 2021 and provide the full outline by the end of May. Mr. Roche, I invite you to brief the court on the timeline for translation. You have the floor.
Thank you very much, Your Honour. As regards translations, we are maintaining progress. As regards the intention or the desire to submit 150 pages by the 20th of April, due to a number of factors, this has not proved possible. This is primarily due to prioritizations in other cases, which have taken some of the resources from the Language Services Unit, and also the nature of the work. It proved that it would be inefficient to focus on 150 pages rather than working through the entire document. As regards the final revised translation, the date of 31st May is still on course. We are finalising the document now, and it will be provided to the parties no later than 31st May. As regards the other documents, which have been prioritised for translation, progress is also very positive. We will have a number of those ready for distribution to the parties by mid-June. The public redacted version of the confirmation decision, which is approximately 300 pages in length, that will not be ready by that time, but a number of the prioritised documents will be prepared by mid-June. Thank you, Your Honour.
Thank you, Mr. Roche. For the future, I invite the registry to provide updates to the parties when deadline that has been foreseen in court cannot be met. Let me turn to the defense if one of the defense have any remarks on this issue of translation, starting with Mr. Prosper.
Thank you, Your Honour. No remarks.
Thank you, Mr. Prosper. Mr. Emerson, please.
Your Honour, I'd like to defer, if I may, on these procedural questions to Mr. Kaufman.
Absolutely. Mr. Kaufman, please.
No remarks on that particular issue, Your Honour.
Thank you, Mr. Kaufman. Mr. Young, please.
No remarks at this stage. Thank you.
Thank you, Mr. Young. Ms. Alagendra, please.
Grateful for the update, Your Honour. No further remarks.
Thank you, Ms. Alagendra. Unless the prosecution has any remarks on this? No. Then I will move to the first topic on the agenda, which is disclosure. I would first like to hear from the prosecution on the progress made on the disclosure of evidentiary material, in particular, whether the SPO has completed disclosure of the remaining material shown to each of the accused during their respective interviews with the SPO. What progress has been made in the disclosure of Rule 1021B material by the SPO by the deadline of 23 July 2021, and in particular, how much of such material remains to be disclosed and whether the SPO envisages filing further protective measure requests for the Rule 1021B material by 4 June 2021. Then whether the parties experience any difficulties with the use of the case-specific categorization of the Rule 102.1b material in legal workflow, as ordered in my Rule 102.9c decision. Then whether the SPO is on track to provide the defense with a detailed notice of evidence falling under Rule 102.3 by Friday, 25 June 2021. Whether there remains exculpatory evidence in the SPO's custody, control, or actual knowledge, and whether this material requires a judicial ruling on protective measures. And finally, whether the SPO is facing or foresees any difficulties related to the disclosure process, in particular with respect to the Rule 107 material, and whether any application pursuant to this rule is imminent. Madam Prosecutor, you have the floor.
Good morning, Your Honor, and everyone in the courtroom. I will give a brief update on the disclosure progress. As mentioned in our submissions, all remaining material shown to each of the accused during their SPO interviews has been disclosed on April 1st, 2021. Additionally, since the last status conference, a further batch of Rule 102.1b material was disclosed on the 28th of April, and 2 further protective measures were filed. We do anticipate further protective measures requests to be filed in relation to Rule 102.1b. All material so far disclosed under Rule 102.1b has been updated to reflect the additional subcategories pursuant to the categorization decision. As mentioned in our submissions, significant registry and SPO resources have been invested with the goal of making these features fully functional. In the meantime, the SPO has worked with the registry to ensure that all previously disclosed material under the Rule 102.1b would reflect the subcategories, and for the disclosures done since then, the SPO has updated the categories manually. We are continuing to work with the registry in resolving any technical issues, which would then facilitate an increase in the pace in which the disclosure packages can be released. Good progress has also been made in the preparation of the Rule 102.3 notice. However, its completion will, for reasons mentioned in our prior submissions, be contingent to a certain degree upon the progress of all of the disclosure. We are also continuing the review of potentially exculpatory material. We have recently made a protective measures request in relation to a small number of documents identified during this exculpatory review. At this time, no further protective measures request in relation to such material is foreseen. However, we will continue to disclose or seek protective measures as required in relation to potentially exculpatory material identified. Concerning Rule 107 material, we are similarly continuing active discussions with a number of organizations in order to release this material. As previously forecasted, it is still the case that we expect certain requests pursuant to Rule 107 will be necessary following the completion of these discussions. We are conscious of the timing and have ensured that the relevant organizations are aware of the deadlines in this case, and we will make those requests as soon as we are in the position to do so. We are now approximately 2 months from the 23rd July date for Rule 102.1b disclosure. As such, this month we are conducting a stock taking, if you will, in terms of disclosure progress. We are assessing the time and the resources that each task takes and measuring it against a projection of what remains to be done. This will enable us to make adjustments where necessary, but because we are in the middle of this exercise, I am not in the position to give concrete estimates of projection resulting from that. exercise. However, I can assure this chamber that the maximum available resources are being devoted to this task. Much progress has already been made, some which is visible in form of disclosure packages or protective measures requests. Some is not yet visible, but hopefully will be in the coming weeks. For example, we anticipate that a further batch of Rule 102(1)B that does not require protective measures will be disclosed shortly in the coming weeks. We will also be disclosing a number of items requested by the defense very soon. Good progress has also been made in linking exhibits referred to in disclosed witness statements as requested by the defense. When possible, we will aim to disclose complete witness packages, but if this is not possible, we will not delay the disclosure. As indicated in our submissions, we hope to be in a better position to provide the chamber with a more concrete perspective in the status conference in June.
Thank you. Thank you, Madam Prosecutor. Before I give the floor to the defense, just one follow-up question on the detailed notice of Rule 102(3) material. I understood that you made good progress, but do you anticipate being able to meet this deadline, or do you foresee a request to extend this deadline?
Good progress has been made, but since we are in the process of assessing a number of issues and the resources, we will have to wait till we finish that process to be able to determine if there's any impact.
So, if I understood you correctly, it is still your objective to meet this deadline, but you cannot be sure for now. Is that correct?
We're in review.
This is noted. Thank you, Madam Prosecutor. Now let me turn to the defense on this issue of disclosure. Mr. Prosper, please.
Thank you, Your Honor. As you can imagine, we are sorting through the material that has been provided by the prosecution. And as has been pointed out by the prosecution, it is not complete. There is still some missing information. We're seeing that there are exhibits that have been referred to in various documents or statements that have not been provided. So we're still trying to process this, but we do believe that more information needs to be disclosed. And there's some information that has been disclosed that has been that is of poor quality and ineligible, quite frankly, for us. So we are putting together a table which we will then go back to the prosecution and try to see if we can sort this out. But I think it's safe to say that it is not complete. Thank you.
Thank you, Mr. Prosper. Mr. Emerson or Mr. Kaufman? Mr. Emerson.
Again, I'm deferring to Mr. Kaufman on these issues from this point forwards.
Mr. Kaufman, please.
Yes, thank you, Your Honour. On this particular matter, I would refer you to paragraph 2 of our filing of yesterday. That's 315 in the case record. All I can add really is that, in our opinion, a pre-trial brief is essential, and there's no substitute for that. We're finding the use of the legal workflow software quite cumbersome and time-consuming. It's not the best application, if I can put it, for assessing the evidence remotely. Now, I do have a more lengthy submission on the Rule 107 issue. I listed it actually under miscellaneous topics to be discussed at the end of the status conference. I don't know whether Your Honour wants to hear that submission now or later.
I'm happy to hear the submission now because this is related to disclosure. So please, you can proceed. Thank you.
Thank you, Your Honour. And as we mentioned in filing 315 submitted yesterday, we have corresponded with the SPO on the issue of Rule 107 material with a view to obtaining certain metadata which would not prima facie violate the conditions of confidentiality applicable to such items of evidence. Now, with what seems to be a rather worrying lack of urgency, the SPO has been insisting that negotiations with the various information providers are ongoing and that discussions on possible counterbalancing measures are yet to be concluded. Now, this response is not new. It has now been given in the same or a similar format at least 4 times. It leads us to believe that little or no progress has been made by the SPO and that it is encountering problems in the execution of its duty, both to review these so-called springboard materials for exculpatory evidence and to make judicially approved counterbalancing paraphrases thereof available to the defence in timely fashion. Now, the metadata which we requested from the SPO were not designed, as I say, to pierce the veil of confidentiality, but rather to allow the defence to be assured, firstly, that the SPO has been attributing Rule 107 status to materials in a lawful manner, and secondly, that the SPO is actually cognizant of the quantity of materials subject to this rule which it has in its possession. With Your Honour's permission, I would just like to take a few sentences to address what I believe to be the lawful use of Rule 107, something which, in my opinion, is clear from the plain language of the statutory provision itself. Rule 107 is essentially the KSC equivalent of Article 54.3e of the Rome Statute. And those of us participating in this hearing, or perhaps not today, such as Mr. Hooper, who are familiar with the DR situation at the International Criminal Court, will be more aware of the hazards associated with this particular prosecutorial minefield. To put it simply, there is a tendency of many prosecutors and investigators, the latter often eager to prove their utility, to seize as much material as possible from whatever organization is willing to provide. Only thereafter, whether by lack of prosecutorial foresight or because the information provider changes his mind, do they realize that exonerating materials seized might not be disclosable, either because there is a risk of exposing a source or because it might endanger the providing organization's ongoing operations. Rule 107 leaves no room for doubt that the prior conclusion of a confidentiality agreement is a necessary prerequisite for the receipt of this information. It cannot work the other way around, namely that Rule 107 label is imposed on materials ex post facto after their provision. If given willingly and without any demand of confidentiality, the information provider cannot at a later stage demand that the information should be withheld. Now, with all of this in mind, the defence asked the SPO to provide it with sufficient metadata to assess whether the materials in its custody and purportedly subject to Rule 107 were indeed supplied with a prior demand for confidentiality. The answer received from the SPO did not differ substantially from the answers given in the last 2 status conferences, and the fact that the SPO is still not able, as they state, to provide meaningful figures as to the quantity of such materials in their possession and whether they contain relevant or exculpatory information is troubling to say the least. So in light of this, we believe that the time has arrived for Your Honour to render a decision imposing strict timelines on the SPO for discharging its disclosure obligations with respect to these materials. We specifically invite Your Honour to order the SPO to provide us as soon as possible with the same information that we requested of it in inter partes communication, namely the number of items purportedly seized pursuant to Rule 107, the number of organizations supplying such materials, the ERN numbers attached to these materials, the date that these materials were created, and the date that these materials were supplied to the SPO. It is this metadata for which the SPO claims to be unable to supply meaningful figures, and it is not clear why this is the case, if it has indeed been receiving these materials as it should. Thank you, Your Honour.
Thank you, Mr. Kaufman. Just one follow-up question, very briefly. The metadata you are requesting are the one you just listed at the end of your presentation. Is that correct? Or is there any other metadata that you are thinking of?
Thank you, Your Honour. Those are indeed the metadata, and those metadata requests were communicated to the prosecution.
This is noted. Thank you, Mr. Kaufman. I'll give the floor to the prosecution at the end. So we will continue with the other defense, but I will invite the prosecution to respond to the arguments of Mr. Kaufman on the Rule 107 material. Mr. Young, please.
Your Honor, I have nothing to add. Safe to say that Listening to Mr. Kaufman, I share his concerns. Thank you.
Thank you, Mr. Young. Ms. Alagendra, please.
Your Honor, may I defer to Mr. Ellis on issues of disclosure?
Mr. Ellis, please.
Thank you, Your Honour. Only one additional point from me this morning, Your Honour, and that relates to our concern about documents seized during the searches which took place in November of last year. Your Honour, we have not yet, I think, received any disclosure of the documents that were seized. Insofar as those relate to Rule 102.1b material, it would be useful for our preparations to know when in the programme of rolling disclosure the prosecution anticipates disclosing those particular documents. But more pressingly, insofar as it relates to exculpatory material, of course the obligation in Rule 103 is to disclose that material immediately. We understand there's a volume of material involved. We understand there may be a need for translation of many of those documents, but nonetheless the searches took place in November. 6 months have now passed, and it would be straining the definition of immediacy at this point. So we would seek immediate disclosure of those materials insofar as they are exculpatory, and an indication as to when the remainder of the materials will actually be disclosed.
Thank you, Mr. Ellis. I turn to the prosecution now, and if you can respond to the 2 points that we just heard from the defense, first on the Rule 107 material, and then on the documents seized during the search in November. Madam Prosecutor.
Thank you, Your Honour. With respect to Rule 107 first, what the defence sought was confirmation that Rule 107 applies to material received under conditions of confidentiality and solely for the purpose of generating new evidence. That confirmation was indeed provided in the SPO's email response, and there is no lack of clarity regarding the conditions under which Rule 107 applies to material. Second, the defence sought a breakdown of certain metadata relating to all items received by the SPO pursuant to Rule 107 conditions. The data was apparently sought in order for the defence to assure themselves as to the timely review of Rule 107 material. However, simply put, the defence has no entitlement to such information, nor does the defence have any legitimate purpose for such information at this interim stage in the disclosure process. It is not entitled to statistical information regarding evidence collected by the SPO throughout the course of its multiple investigations. Moreover, certain of the metadata requested by the defence would in fact violate the conditions under which the material was received, such as, for example, the date of the documents, and in certain cases the ERN number may in fact violate such conditions. The SPO is devoting the SPO's obligations are to ensure that material subject to disclosure in this case is either disclosed or appropriate exemptions from disclosure are obtained. With respect to Rule 107, the SPO is actively and vigorously engaging with relevant institutions. As my colleague indicated, we are aware of the applicable timelines, and we have ensured that the relevant institutions are also aware of them. Even as indicated in our email response, even if the defence were entitled to such data, no meaningful figures are available at this time, and this is for 2 reasons. The first is that the SPO's disclosure review for identification of material which is relevant to this case remains ongoing. Not all materials received under Rule 107 conditions are necessarily relevant to this case. And the second reason is in fact because of the very active nature of the SPO's ongoing efforts with respect to Rule 107 material. The situation is dynamic and it is constantly changing. In fact, just yesterday, a further significant batch of Rule 107 clearances was received. So it is literally the case that the figures are changing on an almost daily basis. As indicated in our written submissions, relevant applications will be made as soon as the SPO is in a position to do so, and to the extent they prove necessary following completion of the discussions. Turning to the second point and the inventory of seized items. In addition to the inventory that was provided to in relation to Mr. Vaselli, and which was filed in accordance with Your Honour's order, the SPO has also provided similar inventories to both the Krasniqi and Salimi defence teams. The seized items are still being assessed for inclusion on the prosecution's exhibit list, or indeed for whether they fall under other disclosure rules, including whether they contain exculpatory information. As was advised inter partes to the Krasniqi defence, to the extent that such materials are not disclosed under either Rule 102.1b or Rule 103, they will be listed in the Rule 102.3 notice. Review of the documents for disclosure purposes remains ongoing, and as the Krasniqi defence are aware and themselves acknowledged, it is a significant volume of material. The index alone relating to Mr. Krasniqi extended to approximately 160 pages. Thank you.
Thank you, Madam Prosecutor. So if I understand correctly on this last topic, what you mentioned is that the defense is going to get the material disclosed if it's 103 immediately, if it's 102.1b by the deadline of 23rd July, and if it's not one of these two, it's going to be in the notice in the 25th of June, correct?
That is correct. Immediately following review and processing, or by the Rule 102.1b deadline, or if not in that, then it will be listed in the Rule 102.3 notice, correct.
And let me go back to the first topic you addressed on the issue of the 107 material. Mr. Kaufman was asking for me to put a deadline on this. What would you have to say on that? And if there was a deadline, what should be the timeline for this obligation to disclose the 107 material?
Your Honour, our submission would be that those deadlines already are in place. To the extent we seek to rely on such information, we have a deadline in place and we are working towards that. To the extent it contains exculpatory information, the requirement is for us to disclose it immediately upon it being available. If at the time that we are disclosing the Rule 102 material, it appears that there remains exculpatory information subject to Rule 107, which has not been released at that time, it would be our intention to begin making applications at that point. Thank you.
Thank you, Madam Prosecutor. Let me turn back to the defense. I will first give the floor to Mr. Kaufman on this topic of the Rule 107 material. You have the floor.
Thank you, Your Honour. Yes, with respect to the lack of entitlement criterion mentioned by the learned prosecutor, that is something new. I would refer to paragraph 7 of our filing, 315 in the case record. The SPO response is set out there quite clearly. Had they believed that we were not entitled to that information, they should have said so right away. This is something new for the purposes of the hearing this morning. But we have put our concern on the record, and we've noted the prosecutor's comments with respect to meeting the deadlines in place. Thank you.
Thank you, Mr. Kaufman. I see that Mr. Prosper requested the floor. So, Mr. Prosper, you have the floor. and after I will give back the floor to Mr. Ellis for the second matter. Mr. Prosper, please.
Thank you, Your Honor. I first would like to join the submission by Mr. Kaufman. But on this issue of 107 information, I think it's important to note a few things. Having been on the other side of this and having been someone who has been disclosing that type of information, it is fairly straightforward. And as the prosecution said, they just received clearance yesterday on a batch. So there should be no reason for that information not to flow, to continue to flow and flow directly. But the main point I want to make is I think it is important for us to have an understanding of the agencies or the type of information that is being sought. And the reason is as follows, is that the prosecution does not have a monopoly on engaging other organizations or other states for information. And if this trial chamber seeks to have this move in an expeditious matter, then I think it would be helpful for us to know what agencies have been contacted. Otherwise, there will be a duplication. And you'll have the defense teams independently going back to some of these same organizations asking for information again and again and again. And not only will it delay the proceedings, but it will really test the patience of cooperating agencies and states. So I think we need to have at least a table to understand what information has been sought, what information has been rejected, and who has been contacted. Thank you very much.
Thank you very much, Mr. Prosper. Mr. Ellis, if you allow me, I will give the floor to the prosecution on this particular point before I give you the floor. Madam Prosecutor, on this issue of sharing the contacts with the different agencies. You have the floor.
First, I would say that the material which has been sought will be available to the defense as it is disclosed, and they will be able to see it for themselves, as well as where it was obtained from, and will therefore be able to avoid any duplication in seeking the same information. As to providing the identity at this stage of organizations that we are engaged with, that would be in clear violation of Rule 107. Thank you.
Thank you, Madam Prosecutor. I don't see any request for the floor on this specific topic, so I give the floor to Mr. Ellis on the other topic we just discussed. You have the floor.
Thank you, Your Honour. Very briefly, what does immediately following processing mean in this context? This is material that the prosecution has already had for 6 months. In my submission, some more urgency is needed on this.
Thank you, Mr. Ellis. Madam Prosecutor, is there any way this can be prioritized within the deadlines that you have?
Your Honour, we certainly are prioritising it, and indeed we had to prioritise it in order to provide the lengthy indexes to the defence recently. It's a significant volume of material which, relative to other material, is relatively recently received. Processing obviously means translation and, as applicable, review for redaction. I can say that there is an awful lot on our plate to prioritise right now. We are simply prioritising it to the maximum extent we can, together with all other disclosure. Thank you.
This is noted. Thank you. I don't see anyone requesting the floor on this topic, so we will move to the second item in our agenda today, which is the defense objections to the admissibility of Rule 102 material and Rule 102 evidence. Let me ask the defense whether they intend to object to the admissibility of evidentiary material disclosed pursuant to Rule 102, and if so, within which time limit. I would also like to hear from the parties about the format to be adopted for these objections. In the scheduling order, I have proposed a table format, including information as to, first, the year and number of relevant evidentiary item, second, the disclosure package number, third, the rule under which the relevant evidentiary item was disclosed, and fourth, the nature of objection. I invite the parties to let me know if they have any comments on this subjected format, starting with the defense. Mr. Prosper, please.
Thank you, Your Honor. I'm trying to understand your question. Objection is to the format of that we will be proceeding, or this you want a substantive response to this question?
At this stage, would you have any comment on the format that I suggested? Would this format suit you for future objections? And are you now able to provide a timeline for these objections or not?
Yeah, actually, I think on both issues, Your Honor, we're not in a position to respond, primarily because it's hard to to object on issues of admissibility when we have not seen the entirety of the package. So we need to understand exactly how the information we are receiving fits together. And once we have a comprehensive picture, we'll be in a position to form a conclusion as to what needs to be challenged on admissibility and how it is to be challenged. And this really comes back to the larger picture, and I do not want to test the patience of this court, but it comes back to this issue that we're getting everything piecemeal. The prosecution has been at this for nearly 5 years and should be ready. And they filed the indictment with you over a year ago, and they are not ready. You know, they complain, they say, oh, we're trying to prioritize, we're busy, we have other things going on. Then my question is, why did you file the indictment? And now what's happening is you have put us in a position where our clients have lost their liberty. They've lost their presumption of innocence because the prosecution is not ready, and we're sitting there at their whim. So it is very, very difficult for us to comment on a completely incomplete picture. And this is very troubling and violative of international norms and human rights instruments. And I apologize for testing your patience, but this is something that is extremely troubling and needs to be remedied immediately. Thank you.
Thank you, Mr. Prosper. Mr. Kaufman or Mr. Emerson, on this specific topic on the objections to the Rule 102 evidence.
I think you've heard enough from me over the past status conferences as to the approach that we take to the way in which the prosecution is going about its disclosure obligations. So I'm going to again defer to Mr. Kaufman, and that goes from this point forwards for the management issues and the implications that they have for the proper conduct of these proceedings and the preparation of the defense.
Thank you, Mr. Emerson. Mr. Kaufman, please.
Thank you, Your Honor. Yes, on this particular matter, we have addressed it comprehensively in paragraph 3 of our filing, 315 in the case record. I would only add that we do not wish to be constrained by any tabular format. The reason for this is quite simple. A trial is a dynamic process, and we can't anticipate all objections in advance to the admissibility of evidence. I would join wholeheartedly Mr. Prosper's submission with respect to not being able to produce any form of objection until we've been disclosed the entirety of the prosecution evidence. Thank you very much.
Thank you, Mr. Kaufman. Mr. Young, please.
Yes, very briefly, I support what my colleagues have simply said for the defence. With respect, it's premature to address the defence comments on admissibility. With respect, Your Honour, we would consider make our objections once we know what the prosecution case is, once the prosecution tell us what evidence, which witnesses and which statement, which exhibits they rely upon. Not at this stage, Your Honour. As far as the table format is concerned, certainly we were able to deal with it in table format at the appropriate time. Thank you.
Thank you, Mr. Young. And on the different categories I suggest to include in the table format, would you be in agreement with that?
Yes, we're happy to consider the categories Your Honour has raised.
Thank you very much, Mr. Young. Ms. Allegendra or Mr. Ellis, please.
Your Honor, our position is as we state in paragraph 8 of our written submission. We are unable to provide a timeline for this. And on that, I take the same position as Mr. Prosper does. Your Honor, on the table format, we have no problems submitting the summary and grouping of the objections. However, on the arguments, that should follow by way of a filing.
Thank you, Mr. Legendra. Let me now turn to the prosecution. Do you have any comments on this topic, Madam Prosecutor?
As indicated in Your Honour's agenda, the objections to admissibility at issue are those addressed in Rule 95(2)(e), and to the extent objections to authenticity are raised by the defence at this stage, they would also be reflected by the SPO pursuant to Rule 95(4)(c) in the exhibit list. In the event of such objections, the SPO considers that the table format proposed by Your Honour would be suitable and useful for the parties and the panel. It will obviously be for the trial panel to set its own directions for the conduct of proceedings at trial and to rule on questions of admissibility. As the SPO understands it, Your Honour's proposal merely facilitates rather than constrains the subsequent trial proceedings. Thank you.
That's correct. Thank you, Ms. Lawson. I don't see any defense team requesting the floor. So we will move to the next topic on the agenda, which is the SPO investigations and next steps. I would like to ask the SPO whether they can provide a further update on the estimated date of completion of outstanding investigative steps, and when the SPO will be able to file its pretrial brief and related material. And on that specific point, I note that the SPO's new target date is now mid-October 2021, according to their written submissions. And I also invite the SPO to make any submissions on the procedural calendar in this case. Madam Prosecutor, you have the floor.
Thank you, Your Honour. The SPO's submissions regarding investigations remain unchanged as indicated in our written submissions. Investigations in fulfilment of the SPO's mandate are anticipated to continue for the foreseeable future. However, this should not impact the pretrial timeline. We are aware that after a certain point, to the extent the SPO seeks to rely on additional evidence, judicial authorization will be required, and to the extent exculpatory material arises, it will be automatically subject to disclosure. As Your Honour noted, with regard to Rule 95(4) material, that is the pretrial brief and witness and exhibit lists, the SPO now anticipates being in a position to submit that material by mid-October 2021. As you indicated, this is a change from the September estimate previously provided. As we had emphasised in prior submissions, both at the last status conference and in written filings, the September date was the earliest possible date that the SPO could have envisaged providing the material at the time. Since then, it has become apparent that all available resources will be occupied with completing disclosure work in the coming months. We are at a critical phase of that process, as we have noted earlier in the hearing, and particularly given the additional logistical burdens involved in it, it's proving to be an all-consuming office-wide endeavour. Disclosure is currently forecast to continue into September 2021, and it is in light of those factors that the SPO has provided a revised estimate. As for the procedural calendar going forward, our submissions would remain as they have done in both written filings and in submissions we've made in prior status conferences regarding the proposed timing following submission of the prosecution's pretrial brief. Thank you, Your Honour.
Thank you, Madam Prosecutor. Mr. Prosper, please.
Thank you, Your Honor. Your Honor, I think the only way for me to describe my reaction is I'm baffled. The prosecution says that begs our patience and that there's a lot of work before them. This is an office-wide effort. I understand that, and it should be an office-wide effort because they have no other mandate than this. I'm not sure what else they may be doing. And it comes back to my point is why are we here if they are not ready? Why are we here if investigations are continuing? There's a fundamental human right due process issue that accused have a right to know why and for what they are being charged. And we do not know. The prosecution continues to say, well, our investigations will continue into the foreseeable future. What is the foreseeable future? I can actually see and program out to 2030. Is that what we're talking about? I think we need to have a timeline and a deadline so that we know what is happening here. And Your Honor, you have already seen their dates are slipping. And I come back to this point that we have people who are deprived of their liberty. They're deprived of their right to in a sense, due process. They're deprived of their presumption of innocence. And the prosecution, it's taking its time. It just says, oh, please, Your Honor, it's an office-wide effort. We're busy. We have a lot happening. Well, my client, all of our clients are sitting in custody away from their family. And they don't even know the totality of what they're charged with because the prosecution is not ready. So there's a simple cure. So while the prosecution continues their investigation into the foreseeable future, perhaps we should revisit the issue and release our clients from custody for the foreseeable future. And then when the prosecution is ready, we can reconvene and start this all over again. But Your Honor, please forgive me for my passion in this, but this is violating every human right norm that is out there as it relates to fair trials. Whether it's from the ICCPR, the European Convention on Human Rights, we really need to take a look at this. And it is a negative reflection on this institution. And by allowing it to happen, it will stain this institution going forward. Thank you very much.
Thank you, Mr. Prosper.
Your Honor, on this issue, I would like to say a
Emerson.
few words before handing over to Mr. Kaufman. You may remember that at an early stage of these proceedings, I foresaw that the planned timetable by which the prosecution was then asking to start a trial in September was completely absurd. And I was accused by the prosecution. In fact, I was also accused in a private meeting by the president of the tribunal of having given a falsely prolonged expectation of the trial, pre-trial phase in order to increase the chances of achieving provisional release. That was the position that was being put in the pleadings. I regret to say it was the position that the president communicated herself to the EU heads of mission in a confidential meeting, of which the details have leaked. We are now in the situation where exactly what I said was going to happen has come to pass. The prosecution is now naming September, the date it originally suggested we could start the trial, and indeed insisted we could start the trial, and that any other time estimate was an abuse by the defense in order to try to persuade the court to grant provisional release, as the date on which the prosecution will certify that it has served its material. We still don't have any indication of when the pre-trial brief is going to be served. It should have been served already. The case should have been ready already. As Mr. Prosper has rightly pointed out, these men are in custody. They're in custody on the basis of the fact that the trial is supposed to be properly prepared and presented and managed. And despite all the detailed micromanagement that Your Honor has tried to do throughout this process, the fact of the matter is that the prosecution is a shambles. And these men are being kept in custody indefinitely whilst the prosecution attempts to put its case in some sort of order. Now, I'd like to add another factor into this equation. I don't know whether Your Honour has yet had a chance to get to grips with the preliminary motions, the responses and the replies, but it will be very obvious to anybody who has that there is a very real issue as to whether this court has jurisdiction to try joint criminal enterprise as a mode of liability, command responsibility as a mode of liability, or arbitrary detention as a substantive offence. These are not issues that are going to go away lightly. It's fairly obvious. There's decisions, a recent decision of the Serbian Constitutional Court, which if it was applied in these proceedings, would have the effect that all of those allegations would be struck out of the indictment. And it is, of course, completely unthinkable that the Kosovo Specialist Chambers, a court of the Kosovo legal system, not an international criminal court at all, but a court of the Kosovo legal system, should treat defendants accused in the KLA in a manner so obviously discriminatory as against the way in which Serbian officials are being treated by their own constitutional court. The fact is that command responsibility, joint criminal enterprise, and arbitrary detention were not crimes in Kosovo at the time the events occurred. The Constitutional Court of Serbia has recognized this and has held that people cannot be tried for those allegations because they weren't crimes at the time. There is no jurisdiction. This court, your court, is in the same position. And to come to an opposite conclusion would be a staggering injustice. So we're in the situation where these individuals are sitting in custody with a prosecution in shambles, with the prosecution accusing the defense of having acted improperly in trying to estimate the length of the pre-trial phase, when it itself was suggesting September, October as a trial date, just at the start of this process, as a basis for resisting provisional release. And on top of that, we're looking at a very real situation where, frankly, the only rational outcome of the pre-trial preliminary investigations is that this court has no jurisdiction on joint criminal enterprise, command responsibility, or arbitrary detention. That being the case, where does that leave the defense? In the case of Mr. Vasili, on the evidence that's been disclosed so far, there is not a single allegation that he perpetrated a crime. There is not a single allegation that he was a co-perpetrator. There is not a single allegation that he incited or aided and abetted any particular crime. There is no case against him if the jurisdictional challenge is correct, on the evidence that's been disclosed so far. Now, maybe the prosecution is holding something back. Maybe the prosecution is hoping something will come up. But you are sitting here presiding over a set of proceedings in which 4 men have lost their liberty for a very long period of time, despite the fact that Mr. Vasili and Mr. Thaci were aware of this indictment 6 months before it was confirmed, despite all the guarantees that have been offered to the court, and despite the fact that Mr. Vasili has very recently had one for which he is extremely grateful, a compassionate period of release, which was extremely well managed on all sides so that he could visit his very sick father. We are in a situation now, and this is where the prosecution, it is the prosecution who has been very obviously acting improperly. And I repeat, I'm putting this on the public record today, not only did the prosecution wrongly accuse the defense of deliberately suggesting that the trial process must be extended, only now to come to the court to say they can't even disclose their case before the date they said they were going to have it ready for trial. Right? Not only did that, but the president of the court, in the presence and with the prosecutor at a private meeting, has made that allegation against the defense as well. This situation is coming to a head. And I would like respectfully to invite you to get a grip on the situation, ensure that these men are not kept in custody any longer, order the prosecution to file a pre-trial brief immediately, and get the preliminary motions dealt with as expeditiously as possible. Because otherwise you're going to find that this court is sitting on 4 men in custody for 2 or 3 years, only to have to decide that it had no jurisdiction to put them there in the first place. So that is my general submission. As far as the details are concerned, I hand over to Mr. Kaufman.
Mr. Kaufman, please, briefly.
Your Honour, I have nothing to add to what Mr. Emerson and Mr. Prosperov so eloquently put.
Thank you, Mr. Kaufman. Mr. Young, please.
Your Honour. Yes, I would like to address you on this because, frankly, Your Honour, we've just heard from the prosecutor about the timeline, and I hope that that timeline that you've just heard from the prosecution is alarming to you, because it's utterly unsatisfactory to have a timeline that is being envisaged. As Your Honour knows, the defendants entitled have adequate time facilities for the preparation of this defence. One of the most staggering statistics is the feature of the translation that you dealt with at the start of this hearing, which is that possibly one of the most important documents that has to be translated into Albanian, the outline document of the prosecution's case, still has not been translated into Albanian. And you may remember last time, Your Honour, at the last status conference, I mentioned how staggering and how difficult this is for the defence, because as Your Honour knows, these accused are entitled to consider the prosecution evidence in their own language. When they cannot even read probably one of the most important single documents in Albanian, and we're now coming up to June, what does that tell, Your Honour, frankly, about the timeline, when that is but one of many thousands of documents? With respect to the translation services, they've tried to prioritize that, but that one single most important document isn't even translated. We're nearly in June. So with respect, it's utterly unsatisfactory. This should have all been prepared much earlier. And with respect, these issues are so serious in terms of trial preparation and giving the defense the opportunity to consider the evidence. How can the defense investigate when the defendants themselves haven't even had the chance to know what the evidence is in their own language and provide instructions to the defense? This is such a concerning issue, Your Honour. I would certainly ask you to, when you review your decision in terms of custody or release, is something that should be, with respect, at the forefront of your mind.
Thank you, Mr. Young. Ms. Alexandra, please.
Your Honour, I echo what has already been submitted by defence counsel, so I have nothing to add.
Thank you, Ms. Alexandra. Before I give the floor to the prosecution, I'd just like to briefly respond to what has been said and to remind everybody in this courtroom and beyond that all the accused are, of course, presumed innocent. And this is something that we all need to have in mind. Madam Prosecutor, you have the floor to respond to the defense teams.
Thank you, Your Honour. Yes, the SPO has from the outset established ambitious targets for itself and continues to do so. We have also welcomed and encouraged active management of the pretrial process. We have done that knowing that the main disclosure burden falls initially on ourselves, and we are doing it in the interests of fair and expeditious proceedings, and we are doing it to ensure that disclosure to the defence is completed at the earliest possible time that it can be completed. It is the prosecution which has been and continues to actively push these proceedings forward. The defence have again made generalised submissions on status and progress. However, the SPO has been and continues to make very good disclosure progress. We've been making regular disclosures well in advance of applicable deadlines. There is absolutely nothing exceptional or in violation of rights or norms in terms of the pretrial progress in this case. Finally, to the extent to which the defence teams are raising questions of detention, I would note that they recently waived the opportunity to make submissions when the timing for detention review arose. Thank you.
Thank you, Madam Prosecutor. Does any of the defense team want to take the floor? Mr. Emerson, briefly then, please.
I will be brief. When it is said that the prosecution established ambitious targets for itself, I really would like to revert to the submission that I made, which was not responded to. The prosecution came before you repeatedly and in written and oral submissions, claiming that they would be ready for a trial in September. They are now saying they are not ready even to disclose their case for it to be investigated until September. That in itself, as everybody has pointed out, is a cause of great concern with 4 men in custody under an indictment which is the subject of a challenge, which, as I say, at the very least is strongly arguable to the jurisdiction of the court on all of the main allegations. But my main concern that has not been responded to is that the prosecution made an allegation repeatedly against the defense and against me personally, as well as against counsel for the other accused, that we were giving the court an artificially prolonged estimate of the pre-trial period in order to support the merits of a provisional release application. That submission was made to you orally several times. It was made to you in writing repeatedly. And as I indicated earlier on, it was made by the president of the tribunal and Mr. Black personally during a meeting with EU heads of mission, which is a matter of very grave concern, which we shall be taking up very shortly. But leaving that aside, I await the apology from the prosecution this morning, please. The acknowledgement that they should never have made that allegation, that the allegation was wrong and unfair, that they withdraw it and they apologize for making it. Because in fact, as we predicted, the prosecution is approximately a year behind the timetable it said it could be ready for. In other words, there's no possible prospect of a trial taking place at any time before the middle of next year on the timetable that the prosecution has now working to. We don't even know what we have to investigate. We've got no idea. Do we have to investigate the crime base when we don't even know if the court's got jurisdiction over joint criminal enterprise? Do we have to, how can we begin the process of investigation when there are no allegations of perpetration or co-perpetration against my client? The reality is you must now accept this trial could not possibly begin before the middle of next year. And that being the case, the allegations that were made against us by the prosecution repeatedly during the phase running up to provisional release and subsequently, and repeated by the president and Mr. Black to the EU heads of mission, are false, they are unfair, they should be withdrawn, and there should be an apology. I'd invite the prosecution to formally now withdraw them and apologize.
Thank you, Mr. Emerson. Does any other defense counsel want to take the floor? I don't see any hands. Does the SPO want to respond?
Just
yes,
very briefly, thank you,
very
Your
briefly,
Honor.
please.
I can return to the ability of the defence to investigate as necessary under the following agenda item. However, the information and materials already available to the defence has been outlined on multiple prior occasions. And we continue to maintain that the timelines forecast by the defence are inflated and that there is no reason why they cannot actively commence their investigations. Thank you.
Thank you, Madam Prosecutor. I don't see any hands, so we're going to move to the next topic, which is the defense investigations and next steps. I would be interested to hear from the defense on the status of its investigation, in particular, whether based on the SPO's estimates and the ongoing disclosure process, the defense can provide more information on the status of their investigations, whether the defense can provide information on any intention to make request concerning unique investigative opportunity, pursuant to Rule 99.1, and whether the defense can provide information on any intention to give notice of an alibi or grounds for excluding responsibility. Mr. Prosper, please.
Thank you, Your Honor. I'll just be brief. I think for the foreseeable future, we are unfortunately unable to provide clarity on these issues until we receive more information from the prosecution. Thank you.
Thank you, Mr. Prosper. Mr. Emerson or Mr. Kaufman?
I'll deal with this if I may. Our investigation team is in place. We are in a position to begin. However, we have done the initial triaging and scoping exercise of the evidence that has been served by the prosecution. And as I have underlined, to my surprise, I have to say, there is not a single allegation against Mr. Vasili of any specific conduct that can be investigated as a crime or participation in a crime. So we are faced with a choice of either doing nothing or investigating those very minor mentions where he appears in the evidence in a non-criminal capacity, or investigating the entire crime base at a time when we don't have the evidence and we don't know what the jurisdiction of the court is to try those allegations. So the short answer to your question is only an insane defense would expend the resources, and I certainly couldn't advise anybody on the defense team to do that, investigating a crime base which in all likelihood is beyond the jurisdiction of this court. What we can do is investigate the very limited references to Mr. Vasili in the evidence, none of which involve the commission of a crime. But as I say, the prosecution so far has served no such evidence. So unless they're holding it back, which would be a disgraceful abuse of process, or unless they haven't got it, which seems likely, there is no such evidence against Mr. Vasili. What investigation can we do? It's true, we can do the investigation of the entire crime base if that really is going to be necessary. But I hope if you've read the responses, at least to the jurisdictional challenge, you will realize why no responsible defense counsel could advise any expenditure at the moment to go reinvestigating 100+ events in 42 different locations across Kosovo and Albania, when there's absolutely nothing legally to connect them to the alleged crimes committed by the accused. So that is our dilemma. As Mr. Prosper has said, what kind of prosecution issues an indictment when the circumstances are as they are, and then insists on holding accuseds in custody and opposing applications for provisional release? What kind of responsible prosecution does that? It indicates 6 months in advance, in breach of the rules, that it is going to indict 2 people for reasons that had no explanation in the order of Your Honour or in the reasons given for it. Then indict them when they are not ready for trial, then give false estimates as to how long a trial can take place. And then we find ourselves in a situation where you're asking us what investigation we can do at a time where it's completely impossible for the defense to know whether they have to investigate almost nothing, which is the current situation, if the jurisdictional challenges succeed. In other words, if this court follows the same approach that was followed at the end of last year to the very same question by the Constitutional Court of Serbia, another municipal court in exactly the same position as the Kosovo Specialist Chamber, if you do the same thing they did and don't set about treating Albanians in an entirely different way to Serbians who allegedly committed crimes in Kosovo at the same time, in the same conflict, at the same place, if there is to be a parity, there will be no trial on joint criminal enterprise command responsibility or arbitrary detention, because you don't have jurisdiction to try it. So what is the defense to do in this situation? Why are we being asked, with the greatest of respect, about the status of defense investigations? I mean, the fact of the matter is that unless this court, a municipal court, and I think everybody associated with the Kosovo Specialist Chambers on the prosecution side and in the registry forgets sometimes that you are a municipal court of Kosovo, not an international criminal court. Your jurisdiction is circumscribed by the Constitution. And in just the same way, the jurisdiction of the Serbian courts are circumscribed by the Constitution. Serbian and Albanian defendants are alleged to have committed crimes in Kosovo at the same time, in the same conflict, subject to the same law, because at the time, the law that applied was the law of the SFRY and the Constitution.
Mr. Emerson, sorry to interrupt you, but this is not the
It is
time and
exactly
the place
relevant
to
your
discuss
question with
the
respect.
preliminary motions.
With respect, it is exactly relevant to your question.
No, we are talking about your investigation. So I definitely, I understood your point. I took note of everything, but now we're not going to discuss in detail about what is going to be in my decisions on the preliminary motion. So,
well, you've read the material, you will see the difficulty. In which case, there's no point in asking the defence, with respect, what the status of our investigation is. Again, any status conference.
No, I perfectly understood your argument.
You can't even begin to answer the question until this court has realised that it's acting in the same status as the Serbian Constitutional Court.
Thank you, Mr. Emerson. Mr. Young, please.
Yes, Your Honour, briefly, at this stage, we're unable to assist Your Honour in terms of information on defence investigations. Suffice to say, our team is expeditiously going through all the prosecution materials. At this stage, I can't provide information on defence investigations.
Thank you, Mr. Young. Ms. Saragendra, please.
Your Honour, we stand by our written submissions. We are unable to give any further update at this stage.
Thank you. Does the SPO want to take the floor on this topic? Yes, Madam Prosecutor.
Thank you, Your Honour. The Vasselli defence have yet again put forward that they are prevented from properly commencing investigations, including pending completion of disclosure, which was one of the factors mentioned in their written submissions. And at this time, they have also shifted ground to make final appeals decisions on preliminary motions a prerequisite to that. As we have previously indicated, the reasons being put forward may justify why the defence investigations could not be completed. They certainly do not justify why they could not be properly commenced. And with regard to the lengthy submissions made by the Vasselli defence, as Your Honour noted, this is not a hearing on jurisdiction. Thank you.
Thank you, Madam Prosecutor. I don't see any request for the floor again on this, so we'll move to the fifth item on our agenda, which is the points of agreement on matters of law and fact. I would like the parties to indicate if they anticipate being able to identify a list of issues subject to dispute and one with issues not subject to dispute. I also invite the defense to indicate if such agreement could be reached before the filing of pretrial brief, or if they prefer not to engage in any agreement before the filing of their respective pretrial brief. We'll start with the prosecution. Madam Prosecutor.
The SPO provided the defence teams with its agreed facts proposal on the 17th of March. As indicated in our written submissions, we've received certain inter partes updates on that matter from the Thaci and Salimi defence teams, but no substantive responses from any of the defence teams to date. With regard to the Vasselli defence submissions and its written filings, the SPO is, of course, aware of the necessity to prove its case at trial and is not requesting assistance from the defence in that. Rather, in the interests of efficient proceedings and in accordance with the rules and the direction of the pretrial judge, we have put forward proposals for the defence's consideration so that, to the extent possible, the proceedings can be appropriately focused. As we've previously indicated, the defence are free to simply indicate agreement or disagreement on each of the proposals. Thank you.
Thank you, Madam Prosecutor. Mr. Prosper, please.
Thank you, Your Honor. I think at the outset, our goal is to make this proceeding as efficient as possible, and to reach agreement where possible. We are in receipt of this document that the prosecution has referred to. I guess one question at the outset is that the totality? Do they expect this document to change? Is this it? Is this the final set of facts that they were asking us to agree to? So I think it'd be helpful to know that. Absent that information, then we're not in a position to even properly consider that information. But again, I just want to make clear that our goal is to make this as efficient as possible. Thank you.
Thank you, Mr. Prosper. Mr. Emerson or Mr. Kaufman?
I'll deal with this very briefly. The earliest date on which the Vasili defence will entertain agreed facts is after the service of the pre-trial brief by the prosecution.
Thank you, Mr. Emerson. Mr. Young, please.
Your Honor, we have been in correspondence with the prosecution in relation to this. We're still actively considering the proposals, and we will respond as soon as we are able. Thank you.
Thank you, Mr. Young. Ms. Alagendra?
On our position is at paragraph 11 of our submissions. We stand by that.
Thank you, Ms. Alagendra. Madam Prosecutor, do you want to respond?
Just briefly to the query raised by the Thaci defence team. At this time, these are the proposed facts that are being put forward by the prosecution for consideration. Of course, as proceedings progress, either the prosecution or the defence teams may wish to discuss further points of agreement, but this is the final list that is being put forward at this time. Thank you.
Thank you, Madam Prosecutor. I don't see any request. Then we're going to move to the last item, but before I give the floor to the parties on the date for the next status conference, I note that, and this is something that has been raised earlier, the Vasili defense, the Selimi defense, and the Krasniki defense indicated in recent filings that they will not make submissions on whether reasons for the continued detention of the accused exist. I informed the parties that following the request from the Thaci defense, I extended the deadline for the submissions of the Thaci defense until 31 May 2021. I would like the other defense counsel to inform the court whether they also wish me to extend the deadline for their submissions, or if they prefer not to make any submissions as indicated in their recent filings. Mr. Emerson, please.
Your Honor, in the light of the developments that have occurred, we had intended to raise the issue of provisional release at an appropriate time between the first review, that's the one that was we're discussing now, the extension of, and the next review, because of course we can reapply for provisional release at any time. It seems with respect that given the way that the case is now developing, it is appropriate for us to make submissions to you on detention review at this stage. And so if you're willing to extend the deadline as regards Mr. Thaci's application, we would be grateful for the opportunity to revise our position and put a submission to you by the end of the month.
Thank you, Mr. Emerson. And do I understand correctly that the date of 31st of May would suit you as well?
Yes.
Thank you, Mr. Emerson. Mr. Young, please.
Forgive me. May I ask if you can hear me, because the connection is very poor?
We can hear you, Mr. Young. Sometimes the image is frozen, but your voice is always clear. If not, I would have suspended the hearing.
Thank you. Well, Your Honor, may I say this, that we will...
And sorry, Mr. Young, of course, the moment I say, Mr. Young, sorry, the moment I just said that, your voice also froze. So if you could start again your submissions.
Actively considering
Sorry,
issue.
Mr. Young, we haven't heard you because, unfortunately, for the first time since the beginning of this hearing, your voice also froze. So if you could repeat your submissions, that would be much appreciated. Thank you.
Yes, Your Honor, I'm sorry, I missed that. There is a poor connection.
We can't hear you anymore.
Nothing to say.
Mr. Young, if I may suggest, could you maybe just inform the court without the video? Because if you disconnect the video, we should have a better quality for your voice, because we haven't been able to hear you in the past minute.
Okay. May I ask, can you?
We hear some words, but not everything. So I think it will be better without the video, because the broadband probably will only be used for your voice, even though I'm not a specialist on this, but that's what a year and a half of pandemic told me.
Your Honor, I have nothing more to add, save to say that we will revert to you as soon as we can, if you can hear me, in relation to the issue of provisional release, which we're actively considering.
But on this, do you wish me to extend the deadline for you so that you can file submissions, as I mentioned and as Mr. Emerson agreed to, or do you prefer that to stay with what you mentioned in your recent filing?
Yes.
I say this because if it's the case, I intend to issue an oral order at the end of this hearing to clarify the matter.
Thank you, Your Honor. It would assist if you did extend the deadline at this stage. Thank you.
Thank you, Mr. Young. And would 31st of May suit you for this?
Yes.
Thank you, Mr. Young. Ms. Alagendra, the same question.
We seek the same extension, Your Honor, and 31st May suits us.
Thank you. Thank you, Ms. Alagendra. This is noted. I will issue an oral order at the end of this hearing on this matter. I would now like to ask the parties for their views on a suitable date for the next status conference. Ms. Lawson for the SPO.
We continue to welcome active management of the pretrial phase, and as indicated in our written submissions, we propose that a further status conference be held in June. Thank you.
Thank you, Madam Prosecutor. Mr. Prosper, please.
Thank you, Your Honor. We're open to a conference in June set by this chamber. The one request I have is if it is at all possible to do it in your afternoon to give me a little more sleep.
The court is very flexible, but the problem that I face is one of the other co-counsel is on the other side of the planet, and it could be very, very late for her. So I think we will engage in consultations through the registry and see the best possible timing for all of you. But what I've tried to do so far is to manage the possibility of everyone to participate, knowing that for you, Mr. Prosper, it's certainly the least convenient hour possible. But we will definitely try to find the best time slot for all the parties and participants.
Thank you. Whatever works for everyone. Thank you.
Thank you, Mr. Prosper. Mr. Emerson, please.
We agree for the proposal for June.
Thank you, Mr. Emerson. Mr. Young, please. Mr. Young, on the date for the next status conference.
Your Honor, forgive me, I've missed some of that due to the poor connection. Safe to say that I would ask for the next one not before the end of June. Thank you.
Thank you, Mr. Young. Ms. Alagendra?
We welcome a June date, Your Honor.
Thank you, Ms. Alagendra. You will receive a scaling order in due course. And as usual, I invite the parties to make written submissions if they would like to raise any specific issue during the next status conference. At this point, I'd like to ask the parties if they have any other matters they would like to raise. Of course, I remind the parties and participants to give prior notice should any submission require the disclosure of confidential information. Madam Prosecutor.
Nothing further. Thank you, Your Honor.
Thank you, Madam Prosecutor. Mr. Prosper, please.
Nothing further, Your Honor. Thank you.
Thank you, Mr. Prosper. Mr. Emerson, please.
Nothing further.
Thank you, Mr. Emerson. Mr. Young, please.
I think Mr. Kaufman may have something to add.
Sorry. Mr. Kaufman, anything to add?
Just 1 minute. Yes, Your
Mr. Kaufman, we can't hear you. I think you disconnected your microphone. Mr. Kaufman? Yes, now we can hear you.
I do apologize, Your Honor. I did raise 2 further issues in our filing 315. One regards the Rule 106 materials. I should like to note that the SPO has indeed been disclosing internal work product emanating from external organizations such as UNMIC, in particular investigators' notes, albeit when it suits the prosecution case, of course. In light of the SPO's inter partes response, which I cited in filing number 315, I would just like to highlight 2 issues. Firstly, we expect the search for material either potentially exonerating or relevant to the defense not to be subordinated to the prosecution's search for what it believes to be incriminating material designed to enhance its case. Secondly, experience has shown us that investigators' notes often contain discussions, internal discussion, relating to a witness's credibility or witnesses' preconditions for cooperation. Now, while such non-exculpatory information could arguably be immune from disclosure as SPO or SITF internal work product, it would not, in our opinion, be immune from disclosure if emanating from any other external organization such as ULEX, UNMIC, the ICTY, or the Kosovo Prosecution Service, and thereafter inherited by the SPO. The other issue which I raised in the filing was the draconian way in which the SPO has applied redactions to the incriminating evidence released under Rule 102, all in the name of witness protection. Now, of course, we're all aware of the purported rationale for the Kosovo Specialist Chambers, but there is a limit as to how far protective measures can be imposed without there being a fundamental breakdown in the ability to conduct a fair and transparent trial. Of course, I'm aware that many of these redactions are subject to the oversight and the approval of this learned bench. Notwithstanding, in our response to the SPO's 6th request for protective measures, that's filing 295 in the case record, we did provide a number for the quantity of witnesses for whom, according to our calculation, delayed disclosure has now been requested. As it stands, and if the SPO were to have its way, I believe that delayed disclosure for up to 30 days before trial would be imposed for something like 50 witnesses, and delayed disclosure for 17 odd witnesses until 30 days before their actual testimony. Now, I seriously do question how the SPO expects the defense to conduct an investigation with such impediments being placed in its way. And I'm the last person to make an accusation of unfair tactics, but intentional or not, we are rapidly being forced to the conclusion that if the situation does not ameliorate, the fairness of the proceedings must, at some stage, be challenged in the context of a petition for a stay of proceedings. Thank you, Your Honour.
Thank you, Mr. Kaufman. I'll give the floor to the SPO to reply after the round of submissions by all the defense teams. Mr. Young, please. Do you have anything else
Nothing
to add?
Thank you.
Thank you, Mr. Young. Ms. Alagendra?
Nothing further to add, Your Honour. Thank you.
Thank you, Ms. Alagendra. Madam Prosecutor, if you want to reply to the submissions of Mr. Kaufman.
Thank you, Your Honour. I would have thought that these matters could both have been raised under the disclosure agenda item. However, in relation to Rule 106, as you will have seen from the prosecution email, which was quoted in the defence filing, although the defence questions themselves were not provided to the Chamber, the SPO has indeed confirmed that exculpatory information contained in internal documents will be disclosed. I don't believe there is anything controversial or in dispute on that matter. With respect to redactions that are being applied, the redactions are being applied to the extent necessary to protect witnesses and other sensitive information, and they are subject to judicial authorization and careful scrutiny. We've previously heard the Vaseli defense threaten for other reasons that they may refuse to participate in the proceedings. Now they are forecasting that they could petition for a stay of proceedings. It appears that generalized and often ill-founded claims are being made almost as a matter of course, couched in hyperbolic language and accompanied by such threats. The defense are obviously free to seek such legal remedies as they consider necessary. However, the proceedings remain subject to judicial oversight and direction at all times. Thank you.
Thank you, Madam Prosecutor. Mr. Kaufman, do you want to reply?
No, Your Honor, I have nothing more to add. Thank you.
Thank you, Mr. Kaufman. I remind all the parties that they can always raise objections to redactions according to my framework decision on disclosure. Now let me give the floor to Mr. Laws. Do you have any topic you'd like to raise, please?
Well, thank you for thinking of me. No, I have nothing to add at this stage. Thank you.
Thank you very much, Mr. Laws. I see that it's already beyond 1 hour and 30 minutes, so we'll have a short break of 20 minutes, and I will come back to issue a couple of oral orders. The hearing is adjourned.
All rise. All rise. Please be seated.
I will now issue two oral orders. The first oral order relates to the issuance of my decisions on preliminary motions. I hereby order that pursuant to Rule 9.5, the time limit for the preliminary motions to be disposed of is varied. The decisions on the preliminary motions will be issued on Friday, 16 July. This concludes my first oral order. Having heard the parties, I will issue a second oral order on the submissions for continued detention. I hereby vary the timeline for submissions and order the respective defense teams to file submissions on the continued detention of Mr. Vesely, Mr. Selimi, and Mr. Krasnicki by Monday, 31st May, and the respective response and replies follow the timeline set out in Rule 76 of the rules. This concludes my second oral order, and this concludes the public hearing for today. I thank the parties and participants for their attendance, and as usual, I thank the interpreters, stenographers, AV technician, and security personnel for their attendance. The hearing is adjourned.
All rise.